This is Andrew Sykes in Pennsylvania, streaming to you live on YouTube, X, formerly known as Twitter, Facebook, LinkedIn, Twitch, a number of different platforms that we're streaming to live, talking to you today about estate planning for retirement benefits. So I'm an attorney practicing in Pennsylvania, and wherever you're watching from, welcome. And I think you're going to find this information useful. I'm going to refer a little bit to Pennsylvania law, but really most of the tips are going to be useful no matter where you are in the United States. So let me go ahead and just dive right into the material here. So a lot of times I think people think of retirement accounts like IRAs, 401ks, 403bs as kind of an afterthought in their estate planning. So they get their wills done, powers of attorney, healthcare directives, maybe a revocable living trust, something like that. And then, finally just to check the box, oh yeah, let's make sure that we have our designated beneficiaries on our retirement accounts. So my suggestion is that it can often involve a lot more planning than that, and they shouldn't be just an afterthought. Your retirement accounts can be part of your integrated estate planning and provide value for your beneficiaries in many different ways. So that's what we're going to talk about today. All right, so an estate planning goal ideally is very simply just to have a plan for all of your assets after death. And in order to understand this and understand the impact of doing good estate planning, it's important to understand how assets pass to heirs. So probate assets, that's something that you would own in your own name individually. That's not beneficiary designated. That's not held jointly or with some designation like payable on death or transfer on death, just something that you might own in your own name, like your house with nobody else on the deed, or a savings account with $100,000 in it, and nobody else is on the account. So those would be probate assets, and those pass through this court-controlled process called probate. So the beneficiaries who would actually receive anything in your probate estate is going to be determined by your will. If you don't have a will, then the state has rules of intestacy that determine where things go if you don't have a will upon your death. So the assets would be distributed at the end of that probate process. Or you might have elected to have a revocable living trust. So maybe now your assets are owned by a revocable trust, and they're going to be distributed according to the terms of the trust. So pretty similar to the probate process in that everything's going to be distributed when the debts are paid and the taxes are paid and the terms of the trust are carried out. So that's different from how retirement accounts work, because those are set up so that they pass by beneficiary designations, so directly to the beneficiaries. And there's a different payout schedule that applies to retirement benefits, and we'll talk about that in more detail. And there are different tax implications because unlike your probate assets, a lot of times there's no income tax implications there, but there could be with retirement accounts. So we want to make sure all the parts are working together, that you've taken into account estate or inheritance taxes, income taxes, and we want to try to get the optimal result. So the challenge is, how can we apply effective, comprehensive estate planning to get great results for retirement plan recipients? So we'll do a quick introduction to some basic rules. The rules can be very complex, I'll tell you, but we're not going to try to get too detailed today. We can go into a lot of rabbit holes that we just kind of make this presentation too difficult for people. But I want to give you enough of the basic rules so that you understand the concrete suggestions and examples and get more out of it. If you do want technical details, I would recommend This book by Ed Slott. I've been a fan of Ed Slott. He's kind of, I think he goes, the slogan is something like America's IRA expert. And he's been writing about and speaking about retirement plans for decades now. I've been a fan of his and read his initial book probably 20, 25 years ago, The Estate Planning Retirement Time Bomb and How to Defuse It, I think was the name of it. And what I like about his writing is that it's always accurate and detailed, but it's very understandable and even entertaining. So it's a great way to learn these rules. So I have my copy here that's updated. It's now called the Retirement Savings Time Bomb Ticks Louder. And I have my tabs over here from when I went through it and marked certain things that I want to make sure that I remember and go back and refer to. I think this the audio is going to be a little bit better now. Sorry about that. Okay, so yeah, so Ed Slott is very detail oriented and has a lot of the technical details that you can rely on. All right, let's get into some of these basic concepts, enough to understand the examples anyway. So the first is qualified funds as opposed to non-qualified funds. So qualified funds are funds that are in a retirement account like an IRA, 401k, 403b, SEP IRA, all those kinds of things. And the idea is that usually if it's a traditional account, then the taxes haven't been paid on that yet. So there are going to be tax ramifications along with that. Related to that is traditional accounts versus Roth accounts. So a traditional account is one where there hasn't been any taxes taken out at the time that the contribution went in. Okay, so if you had an IRA, you're putting something in, you take a tax deduction every year. Or if you're at work and you've got a 401k, the amount is not going to be have taxes taken out initially. Taxes will be taken out later when you take a distribution many years from now, after hopefully it's grown in value. And now with a Roth account, that's a situation where the taxes have been taken out when the contribution was made initially. Or if you had a traditional account and you've converted it over and paid those taxes, a Roth can be set up that way too. But the key is that when you take out distributions, eventually they come out tax-free. So that's an important distinction too, because we're going to talk a little bit about income tax implications. All right, another important concept, the Secure Act came out in 2019, and the Secure Act 2.0 came out in 2022, and the IRS has been implementing regulations since then, and they just finally had the finalized one in the final rules came out in December of 2024. So as I'm doing this live stream, it was just last month. So the Secure Act and the Secure Act 2.0 changed some of the rules for how retirement accounts work. Didn't change all of them. So one that stayed the same was when you're allowed to take distributions out without any kind of penalty. And that age is 59 and a half. So, so again, you're putting contributions in during your working years, and then you can't take it out before 59 and a half without taking a 10% penalty. And it's not a good idea anyway, because you're trying to build up your retirement account. But before then, there's a 10% penalty unless you meet some sort of exception, like you're disabled. So when you're 59 and a half, now you're allowed to take it out, but you're not required to take out distributions. Until you get to your required beginning date. So RBD, required beginning date. For years, that was 70 and a half. You might have heard of that. I don't know where they came up with 70 and a half, but that was the rule for years. It was like April 1st of the year after you turned 70 and a half was when you had to start taking required distributions. So that was one of the things that the Secure Act changed, was the date. So it became 72. Now it's 73. And it's going to change again in 2033. So if you're turning 75 after that, then your required beginning date will be April 1 of the year following when you turn 75. So the easiest way to remember it is if you were born 1950 or before, you're already past the date, your required beginning date. Anybody born 1951 through 59, they're going to be, the required beginning date is going to be 73. If you're born 1960 or after, then your required beginning date will be April 1st of the year following when you turn 75. So this becomes important when we look at tax deferral and growth. All right, when you do have to start taking distributions out, there's this concept called required minimum distributions, RMDs. And for that, for a lot of people, that's the uniform life table. And this life table that the IRS puts out has an amount that it gives you the number of years of your life expectancy, and that's used in the calculation of your required minimum distribution. So you don't have to know all these rules. So one of the nice things is that these days, if you have any type of retirement account, the company is required to calculate this for you. And it's based on the amount that you had in the account at the end of last year. So what you had on December 31, 2024 is going to determine what you're going to have to take out in 2025. So it's the total amount on that date divided by the amount from the table. So I think now if you're like 75, it's something like 25.5%. So you'd be taking out about 4% if you're around 75. So the nice thing is, if you're wanting to get the best result, tax-wise and growth-wise, just take out that 3 or 4% that you're required to take out, leave the other 96.5% in there to grow tax deferred for the next year. So usually the goal is tax deferral and growth. Okay, but I'm going to say it's usually, but not always. So there might be situations where maybe you're 68 today, and you know that you can defer until age 73 before you have to start taking out your required minimum distributions. So you could defer it, but when you talk to your tax accountant, your tax preparer, your financial advisor, there might be some reason why, if you waited until 73, in your situation, the distributions might be large enough that it would put you in a different tax bracket, or might affect your Medicare premium, something like that. So it's not always the case, but it's often a goal to have tax deferral and growth. So for the rest of the presentation, I'm going to assume that is the case, that we're going to want to defer taking money out and let it all continue to grow tax deferred, and have a bigger pot for yourself during your retirement years or for your heirs. All right, so inheriting a retirement account. First thing is it has to be renamed for the beneficiary. So here's an example from the Ed Slott book that I mentioned earlier. Ann Smith, IRA, deceased May 15, 2023. FBO, that is for the benefit of Brian Smith, beneficiary. So it would just be retitled into a new account. It's not in Ann Smith's name anymore. It's not exactly in Brian Smith's name. It's retitled to make it clear that it's an inherited IRA. So another thing that the Secure Act did was to change the rules for when the money must be taken out. For a lot of beneficiaries, the rule is 10 years. Now, this was a dramatic difference from before Secure. Before the Secure Act came out, a beneficiary would be allowed to take it out over their life expectancy under an IRS table. That was very beneficial. So, somebody inheriting at a younger age might be allowed to take it out over maybe 20, 25 years. So the Secure Act was favorable in the sense that it allowed participants to take their minimum distributions later in life, but then it also required people who were inheriting them to take it out more quickly in most cases, and not have that long stretch that many people did before the Secure Act. So if you're a participant, you can leave it tax deferred later. If you're somebody inheriting it, probably going to have to take it out sooner and pay the taxes sooner. So that was kind of the point. For many beneficiaries, that's 10 years. So somebody who's 50 years old, inheriting from somebody who's 80 years old, might have to take that out within 10 years. So in many cases, not as beneficial, but these are the new rules. Under the Secure Act, there are certain favored beneficiaries, such as a surviving spouse. So a surviving spouse has one of the best deals around. They can, if they want to, just roll it over and make it their own retirement account, as if it had always been their retirement account. They would also have the ability to elect to become a beneficiary if that's more beneficial. And we'll look at an example here soon. A minor child. This doesn't happen all that often. If you think about it, maybe I think Steve Martin had a child in his 60s. So maybe if he passed away at 80, right, might have a minor child. But for most people, they don't have children of their own that are minors, unless somebody unexpectedly passed away early in life. So somebody that worked for 20 years, accumulated a lot in their retirement account, and then passed away at age 42, might have minor children. And it doesn't apply to grandchildren. So the minor child has to be a child of the participant who passed away. So they get more beneficial treatment because the 10-year rule applies, but it doesn't start until age 21. So if you're inheriting, if you're a beneficiary and you're 10 years old, hopefully your parents or somebody will, guardian or somebody will help you to make sure that you take it out over the longest period of time that you're allowed. So, at age 10, you wouldn't have to take all of it out until 31, right? Because your 10 years begins at age 21. So you might have 21 years there to take that out. Disabled beneficiary, chronically ill beneficiary, they're using the old favorable rules before the Secure Act, where they take it out over according to a life expectancy table. So that's in many cases more than 10 years. There's also the situation of a beneficiary less than 10 years younger than the participant. So a sibling, a friend, cousin, unmarried partner. So that's, if the unmarried partner is not more than 10 years younger than the deceased, that's not as good as being a surviving spouse in terms of the favorability of it, but it's better than just 10 years in a lot of situations. All right, so what you want to try to avoid if you're looking for tax deferral and growth is the 5-year rule. So in some cases, the account may need to be distributed over 5 years if the beneficiary is like an estate. If you had named in your beneficiary form, my estate, or maybe you didn't name any beneficiaries, and under the plan's rules, it gets paid to your estate. Or you named a sort of garden variety revocable living trust as the beneficiary. There's something called a see-through trust that the IRS has a regulation on. And if the terms of a see-through trust are followed, that can give the designated beneficiary of the trust the same payout schedule that they would have if they were named as an individual. But if you just name my revocable living trust and it's not set up as a see-through trust under the IRS's regulations, then you might get stuck with this 5-year rule where everything has to get paid out within 5 years. So suggestion number 1 is simply to name a person, a living, breathing person, to be your beneficiary or beneficiaries. So we can see then, if you do that, you're avoiding the 5-year rule, and you're at least giving them the 10 years, right? So you've doubled it, given the additional amount of time. And you might even give them a longer pay schedule if they are one of these favored beneficiaries. And if you've named people individually, those persons may have other favorable options. So let's take an example of David, age 75, and Angela, age 65. And let's assume that David and Angela are married. So David dies first, so he's age 75, and Angela wants to defer distributions as long as possible. So we know since she's age 65 now, she doesn't have to take her distributions for her accounts until she's age 73. So what she would want to do would be to take David's retirement account and roll it over, make it her own, and then she doesn't have to take it out until she gets to be her required beginning date when she gets to be 73. On the other hand, if Angela dies first, now she's younger, and David wants to defer distributions. So in this case, he would not want to roll it over and make it his, because if he did, now he's already 75, he's past 73, he'd have to start taking distributions right away. So in this situation, he could elect to take it as a beneficiary and then wouldn't have to start taking it until Angela's required beginning date. So he'd get another 8 years to do that. Now let's suppose you have a surviving spouse who's age 40. Now that's somebody, if they wanted to roll it over, make it their own, they can defer, let's say at age 40, they wouldn't have to take it out until they're 75 if they're 40 now. So they get, another 35 years to defer distributions and have tax-deferred growth. But keep in mind that's not always the case. And here's another way that you can maybe, beneficiaries can use these rules to their advantage. It could be that somebody who's a widow or widower at age 40, they might need money, and they might want to take that now. And remember the rule about if it's before 59 and a half, there might be a 10% penalty. So if they just rolled it over and made it theirs, they'd be subject to penalty for taking it out now. So that's another situation where the surviving spouse might want to elect to take that as an inherited IRA, just be a regular beneficiary, so that they'd have access to it sooner without having any 10% penalty. Okay, want to check and see how we're doing on time. Good. Okay. All right, let's get on to suggestion number 2. So in addition to naming an individual, you can also name a see-through trust for a person or persons to be your beneficiary or beneficiaries. For example, maybe you might want to do that for creditor protection. One of the advantages of retirement accounts is that there are protections that you get from, creditors, lawsuit judgments, this sort of thing. If you remember back to the O.J. Simpson case, it was very widely followed in the 90s when this occurred. O.J. Simpson was accused of killing his ex-wife, and he was not criminally prosecuted, but he was held liable in civil court, and had to sell his house and his Heisman Trophy and a lot of possessions. So a lot of assets got lost to that judgment. But what really saved him was that his NFL retirement was not subject to judgments. So he was able to live comfortably for many years because of that. Now, that same protection doesn't apply to protection from bankruptcy, things like that doesn't apply necessarily to the next generation. In fact, in the area of bankruptcy, there was a Supreme Court case maybe about 10 or 12 years ago where the Supreme Court decided that somebody who had inherited a retirement account and then went into bankruptcy, that inherited account didn't have the same protection as if it had been that person's retirement account. They decided that, the retirement account protection was only for the participant. If you're getting inherited a retirement account, then it's subject to your creditors if you go into bankruptcy. So by setting up a see-through trust under state law, you can provide different protections like creditor protection. So maybe your children are in the medical profession or the legal profession or construction, people that get sued often, and you want to provide creditor protection there. Or maybe you have a beneficiary in your family who has special needs, and you want to make sure that, what you leave them doesn't throw them off their SSI or Medicaid benefits, and they're not allowed to have anything over a certain amount in the way of assets. Putting it into a special needs trust would be a way to preserve that without affecting their benefits and providing additional protection. And another thing that you might want to think about would be enhanced divorce protection. So these are certain ways that you can provide protections through state law. And if it's set up to be a see-through trust, you're not going to adversely affect the tax deferral and growth, right? Because the IRS considers that a see-through trust for the benefit of someone who is an individual gets the same payout treatment as if you had named that individual themselves, right? So if you name your child who gets 10-year payout, they would have the same 10-year payout, not a 5-year payout, even though the money from the trust ultimately ends up in a see-through trust that provides these additional protections. All right, suggestion number 3 is to name charities wisely. And the reason for that is that if you name a charity and it's qualified charity, 501c3 charity, then that amount that gets paid to them is not subject to income tax. So to illustrate this, I have this example. Looks like the formatting on this platform got thrown off a little bit, but I think we can still read it. Joe has $1 million in non-qualified account, and he also owns $1 million in a traditional IRA. So we know from one of the previous slides that the non-qualified account is going to be a probate asset. And Joe comes into the office and he wants to write a will leaving $200,000 to his church, right? He's a believer in tithing, and so he wants to tithe and leave $200,000. This was actually based on an actual client whose name has been changed, but wanted me to write a will leaving 10%, right, to his church. So he wants to leave $200,000 in his will, and he was going to name his children to receive the rest of his probate assets and to receive 50% of his retirement accounts. So let's see if we can get a better result for Joe. All right, so how about if we name the church to receive 20% of his $1 million traditional IRA and the rest to go to his 2 children equally. And then in Joe's will, he's just going to leave everything to his 2 children. So now he's leaving all his non-qualified funds, all of his after-tax funds to his children. And then in his IRA, they're going to get a greater percentage that's going to be tax-free. The amount going to the church is going to be tax-free because of the exception for charities. So this is a better result where he's going to maximize the amount and get more bang for his buck just by simply making this change. Suggestion number 4 is to make sure that you're providing liquidity to pay any death taxes. So now I'm going to refer to Pennsylvania law a bit here, but there may be death taxes or whatever state you live in, and it's kind of the same concept here. If there are debts or taxes or costs of administration, anything that needs to be paid after your death, want to make sure that there's some money set aside for that so that you don't have to take money out of a retirement account. Because when you take the money out of the retirement account, if it's a traditional account, your heirs are going to be paying taxes on that and might have to take out a greater amount, to pay the taxes and then pay whatever debts or taxes remain to be paid. And you also want to make sure that you're not adversely affecting one of your beneficiaries. So let's go through this example. So Tina's will leaves her $500,000 house to her daughter. And then Tina has an unmarried partner and leaves her unmarried partner a $100,000 savings account that's payable on death. So it's a non-probate asset. And she also leaves her unmarried partner a $400,000 traditional IRA. All right, so her thinking is I'm treating them equally. I want to give half to my daughter and half to my unmarried partner. Now, the problem is that she doesn't see, and she might not have noticed in her will, it contains this clause. I would not usually put this clause in a will, but I see them a lot in wills that people get prepared other places or online or who knows where, that essentially says that all death taxes are paid by my probate estate and do not come from any other beneficiary. So the result in Pennsylvania would be that because her partner was unmarried, is not a surviving spouse, under Pennsylvania law, that'd be subject to inheritance tax of 15%. So the amount that the unmarried partner got from the IRA and from the savings account totaled $500,000. So that's going to be about a $75,000 tax bill. Now that's going to have to come out of Tina's share, right? Let me go back a slide here. So Tina's getting a $500,000 house. Now she has to pay a $75,000 tax bill for the unmarried partner because of the way the will was written and because of the way things were titled. So she might have to end up selling the house just to pay all of the inheritance taxes. So if you want to get a better result for Tina, let's say that we take that $100,000 savings account and split it up. So we're going to leave $25,000 payable on death to her daughter, and Tina's still leaving her the house. And at the rate of 4.5% inheritance tax, which Pennsylvania has for children, that would be $22,500. She'd be able to pay the inheritance tax and not have to sell the house. And Tina would leave her $400,000 IRA and the other $75,000 of the account payable on death to her unmarried partner. So, and then she'll change her will to provide that each beneficiary is responsible for inheritance tax on their proportional assets received. So Tina's daughter should be able to pay the taxes and not have to sell the house. And the unmarried partner, I think it's pretty fair to them as well because they're still getting almost half of the estate. And because she's provided some liquidity. She's not, the unmarried partner is not going to have to take $75,000 out of the retirement account to pay the taxes. They can use this savings account, pay the taxes, leave the IRA intact, and if they're not more than 10 years younger, right, should be able to take distributions out over an extended period of time and get a lot more out of the IRA. So I think this is a good result for everyone. All right, suggestion number 5, make the retirement plans part of a multi-generational asset protection strategy. So here I copied this chart, and I'm not sure how this is going to show up, but maybe I can make it larger. Yeah, let me just put that there. So I'm not sure you're going to be able to read this depending on what computer you might be watching this stream on, but I can kind of narrate this for you. So the yellow, excuse me, the yellow line on the left shows tangible personal property, so things like household items. And then the next one over, these would be other assets that are outside of the trust. But the key one here is the tan section in the middle. So this is this is for distribution of assets for John and Jane Doe, obviously fictional. And we've established the Doe Family Trust. This would be an irrevocable grantor trust set up for asset protection during lifetime. And the key components there are that, it has immediate protection from, creditors and judgments. And then after 5 years is not subject to nursing home spend down. So we're protecting a lot of assets in that way. Also avoiding probate for anything that's in the trust. And eventually that's going to end up at the bottom of the screen after the second spouse's death, going into 3 little buckets there. So these are some separate share trusts for each of their children, Ken, Barbie, and Gloria Doe. All right, so these are set up so that they're the trust's assets are fairly readily available to the beneficiaries, but are protected in the case of, the beneficiaries getting divorced or getting sued or having nursing home spend down issues themselves. All right, so these things are set up to give greater protection for all the beneficiaries and give them protection going forward so that whatever remains in their trust that they haven't taken out would be protected in case maybe they get divorced a few years down the road. Now, the orange set of components over on the right side, those are the retirement accounts. So remember when we talked about see-through trusts, all right, this is going to be set up and we're going to have the same asset protection trusts down there at the bottom for the 3 beneficiaries. It's going to be set up the same way and have the same protections, but be set up separately for tax purposes. And because they're see-through trusts, then they're going to get the same beneficial payout schedule that they would if the beneficiaries were all named individually as individual persons. So this is the example of how things can be put into a comprehensive strategy where we're going to have asset protection during lifetime for John and Jane Doe, and then asset protection for all of their kids, not just for anything they have in the trust, but anything they have in their retirement accounts as well. Okay, so we're not going to have time for questions today, unfortunately, but our intention is to post this onto YouTube eventually, an edited version of that you can go back and watch. And if you have any questions, put those in the comments and we'll get to those when we can. Well, thank you for joining us here today. It's good to see everybody that was able to join, and keep an eye out for our upcoming live streams. And I hope you got a lot out of the information here and that you found some useful tips that will be actionable for you or for your clients. And we'll see you next time.